First of all, good morning. Thank you for being here. I want to thank our panel, Grayson and Nathan. I think we have some really good practical points, and we're going to sort of go in a pattern, but we definitely have saved a lot of time for questions. I told Nathan he is, as the title person here with real estate, it's probably going to be the King Nathan show. So he is definitely an important part of this, because we all know that real property is such a big deal for our clients, you know, in these matters. I also want to thank my team at Pendleton Square. Colleen Moore helped with this presentation. Brendan Horton, our fiduciary counsel, pulled some information for me, and Cindy Harper, our tax director, was really helpful to talk about just the basics on what we need to know. So with that, we'll move forward. Hopefully I can sort this out. All right, so first of all, what I just wanted to do, this slide, the credit needs to go to Jill Mastriani, who used to be with Holland and Knight, and this was a slide we used last year in a talk, and it's basically probate and non-probate assets. I'm sure this is a 101 for everyone in this room, but we are really going to deal over there on the left, the blue bucket, all of the things that you might see or certainly have seen, you know, with your clients. And one thing I want to point out early on here is sometimes people come to you and there does not need to be a probate. You look at it, you know the assets, non-probate assets, but there's a will. And we just want to point out that it is a really good practice to lodge that will at court in the county where the decedent lived or, you know, was a resident. You don't have to. Grayson and I were speaking today. It's the criminal penalty is if you are asked and don't produce it. So don't let someone say, "Oh, I don't want Mama to see it. I don't want Brother to see it."
Or if you willfully disappear it for the purpose of preventing its probate. Mm-hmm. So
absolutely. If you can't find it in your file, but you know it's back there, you need to get it out. So that's something to keep in mind. But this is a great slide. I just, wanted to put this up first here just to quickly talk about it. So perhaps you don't need to go to probate court. So the things that we're going to hit here is not avoiding probate. This is not about estate planning. This is about you're already there. So, there may be bank accounts, there may be a car, there's personal property. What about the income tax return for the person? We're going to talk about the small estate and muniment of title statutes. Grayson's going to go into detail on that, because we have a lot of tools in the toolbox. And then real property, Nathan is going to help us there. So I think one thing that's important too, when we talk about just wills, most counties you can lodge the will. If there's an original will and someone comes to you, it's not needing to be probate, you can lodge it. It's just a few dollars and you can get that in there. If there's a creditor or something that comes up later, they can get it. And then they always know where the original is, because maybe it needs to be probated, years later. As we all know, there's nothing to do at the first death. I always get frustrated when I hear that. But that myth is still out there. And the other thing also is if somebody comes to you and you're not thinking you need to probate, it's really a great idea just to quick Google that obituary. People lie, which is shocking to me, but it does happen. I'm still getting used to that. Thankfully, it doesn't happen too often. So anyhow, this is our roadmap where we're going. Now, tax. I am not a CPA, and we do not prepare tax returns. But if someone comes to you and they're like, we don't need to probate, mother had nothing, you need to maybe suggest they talk to a CPA or find out what happened last year with the tax return. So this chart, there's a link in the materials, it's on the IRS website. And notice married filing separately there in the middle, any age, $5. So there's a low bar there. But I think it's important, not that we have to memorize this, but you just need to know, you might need to file an income tax return. You might need to guide your client to do that. And it's easy to say, oh, they had nothing or they had very little or, so it's just important to think about that. So that leads to this, always check with the CPA. And one of the things that we talked about a little bit on this panel is, and Grayson, I'm going to throw this to you for a second, the loss leader. If you're not probating, let's talk about that from Lawyer Land.
So tell me exactly what we're talking about.
Just if a client comes to you, they don't need to probate, and yet they need some help. They maybe have a car, they maybe have a bank account, and you're not going to handle that matter. It's not a big matter.
Right, but you can also provide a lot of help and advice. There are a lot of self-help tips that you can give people, such as how to deal with the car, which I think Elizabeth is going to talk about in her materials in some more detail, or how to deal with a bank account that is under a certain amount, and you may be able to obtain the amount of that bank account without actually probating. So there are a lot of little things that you can do in a simple consultation to help your clients. That you're not going to be doing full probate. This is not going to be a big money case, but these are things that are really helpful to real people that you deal with every day. And even though you may not be bringing a bunch of money in the door on this matter, you're earning somebody's undying gratitude. And if later they do have an estate that is larger and that they need help with, then you've got a client for life, and that part's really cool.
And that's a really great point. Or planning, their business takes off and they remember you helped them, with their brother. So just tax considerations, who can sign a 1040 if there's not an executor or trustee or spouse? The power of attorney, if there was one. And then funeral expenses, it's important. They can really only be deducted on a 706 estate tax return. You can't deduct them there. And there is some information on medical expenses, and that's often a consideration. So there's just some things in the tax code that might be helpful. And I think as attorneys, we don't need to be CPAs. It's wonderful, and I know those are out there, but at least know when you need to talk to another professional, to make sure that we have this conversation. I think that's really critical. So vehicles, this is a huge one because most people have a car or, several cars. So the first point here, encourage clients to be courteous and start, not end with a supervisor. And I think that is really important. So often when dealing with vehicles, who you get at the window is the way it goes. And a lot of times, they're in a hurry, they're busy, people are not nice. And so being nice and saying, hey, this has happened and I need to deal with this. This is a car that, my dad had or my sister had, and, there's just two of us left and we're here. So it's important just to navigate this and understand so you can help your client. I always used to say, go ahead and fill out the affidavit of non-dealer transfer. You may not need it in your county. There is inconsistencies, I will say. But you don't have to pay transfer tax if you are a relative transfer. And there's a lot of relatives, spouses of children, grandchildren, great-grandchildren, can also, have that tax exemption. There's an affidavit of heirship, and there's a link here. This is great if all of the children agree that one child is getting the car. They just need to sign off on it. There's a link as well, but you're going to really help your clients if you understand they need to do this. And this is how it gets done. And don't just keep driving the car and hoping nothing happens. That's not a really good plan. And keep it insured. So one of the things that I really wanted to point out is there's a relatively new law in Tennessee, TCA 32-615, settlement agreements for estate administration. So this law tracks a very similar law in trust world that trusts you can do a basically non-judicial settlement agreement. So the legislature extended this to estates. Now I throw this in here, and there's multiple slides, and we're not going to get into it because want to make sure we have plenty of time here. But the main point is that anybody can agree to anything. So let's just say if somebody's brother-in-law is like, that Corvette is mine, and everybody, in the family is like, okay, he gets the carcass of the Corvette that's been in the garage. We're all going to sign off on it. The lawyer can write up an agreement. And then 10 years later, when somebody's wife or husband is like, you stole that Corvette that was in that back garage, no, we have an agreement. So it can, I think, prevent problems. And I know you've used them. I've used them as well, and trusts a lot.
Oh, yeah. It is really helpful. As long as you're dealing with a group of competent adults, then you can agree, and I realize that's a large caveat, okay? I get that. I hear y'all. But as long as you are dealing with competent adults who are the heirs or beneficiaries, they can agree to just about anything. And this statute is nice because it kind of gives you a framework for doing it. I've often done them outside of probate, and not found a need to actually file them with the court. You don't really have to unless a dispute ensues, but it's useful to have it sort of as a backup, like a belt and suspenders, and that way your agreement is in writing, and so it's much harder for someone to change their mind. Mm-hmm. So
exactly, or forget.
Yes,
5 years
forget
later.
that.
So I think that I love family settlement agreements, as generically call them, and that's something if you have a client come to you and they're like, we all agree, but I'm a little worried about brother-in-law or whatever. Think about that. It's a tool in the toolbox. You don't have to have it approved by the court. I've done it both ways. I've done the agreement and shared it with everybody, and I've done the agreement and taken it to court if there is a probate that's open, to get it blessed by the court. So great tool. I'm not going to go into all of the details. There's a lot of information here. Relatively new law. You just should know about it. What about that bank account? So there is a statute, 452708, payment when no executor or administrator qualifies. Note the important note under here. Don't be surprised if this doesn't work. So we're going to talk about small estate and muniment in a minute. But
yes.
This is a challenge, and it makes sense that it should be a challenge. Banks have a business. They are worried there's rampant fraud, and they have to be careful. They have a lot of rules and regulations, and I think as attorneys, we need to work in the matrix, and they're in there. So this is a statute, and I'm sort of moving fast here, but there is a way, and you might need to, as the lawyer, be helping your client get that money from the bank. So just good to know about this statute as well. There is a safe deposit box statute as well about the death of somebody having access and who can get in, what they can do. So this is really important that here, you can, if there's an original will in that safe deposit box, you can get into it. The problem comes if nobody has a key, and then you have to get a court order to drill the box. But this is something that, and I encourage people, if you have, banker colleagues, and there's banks here, ask them how their department deals with this, especially if you're in a town and a lot of your clients are at a similar bank or one or two banks. As lawyers, it pays to kind of understand what are the rules on this? And again, it may take muniment or small estate, but there is a safe deposit box statute.
Yeah.
So it also references priority of claims, so I threw this in here. It's very important for us to remember this, especially when clients come to you all and there are some things to be paid. You sort of just need to know, be reminded there's definitely an order. Cost of administration, that includes paying lawyers, is number one, sort of a surprise. Funeral expense, taxes are third, but remember, if somebody's not paying the property tax, the land may not even be there. So that's important. So that's that. And with that, I'm going to toss to muniment.
Thank you so much. And Elizabeth, if you wouldn't mind running my slides for me, since I have very short arms, I can't reach over there.
Just let me sort of, let me know.
I'll tell you when to. So, it's always a good thing to have tools in your toolbox for when you have a client come in and you realize, I mean, there's nothing to probate here, we really don't need to do that. Maybe there's a less, I don't want to call it intrusive, but a less substantial step that you could take to help this family get where they need to be. Because ultimately, probate is about transferring the assets of the decedent to where they ought to go, either by terms of the will or by terms of the law of intestate succession. And it's all about how do we get that stuff transferred? How do we get it to the right place? You know, I've always said that the amount of difficulty and struggle in a decedent's estate is in direct inverse proportion to the amount of money involved. How many of you have experienced that? You know, you have these multi-million-dollar estates and everything just flows, it's smooth like butter, and then you get people who are arguing over grandma's old kerosene oil lamp, and you're going to spend $10,000 arguing about it in probate. I mean, it really is that way. But these are some ways that are maybe more cost-effective that you can help people deal with things that perhaps don't need a full probate or estate administration. So we're sort of progressing from like no probate whatsoever to a little smaller scope of probate. The first one is monument of title. And this statute here is sort of the genesis of where monument of title comes about and what it means. And this is the entire statute, this is the entire portion of the statute. It just says that probate of the will is sufficient evidence of the devise of real property. That's Tennessee law. So what that means is that if you have a will that has been probated and has been determined to be a valid will by the court, then it is effective to pass title to real property. And for a number of years, that was all we had. And then the legislature passed 32-2-111, which actually sets up a formal statutory proceeding for monument of title. And it provides that we can admit a will for probate for the limited purpose of establishing a monument of title to real and personal property. That's actually included in the statute, without the necessity of granting letters testamentary or otherwise proceeding with administration. So as you can see, monument of title only works when you have a testate estate, when there is actually a will. It's not applicable when the decedent died without a will, but it's sort of a low-level way of getting that will admitted for the purpose of establishing ownership of real estate. The typical scenario in which I would use something like this is where widowed mama, dies owning a house and a couple of small bank accounts, and her bank accounts are joint with right of survivorship with the kids, and so there's really nothing to worry about passing title to except that real estate. And so rather than opening a full probate where you may have creditors show up or people show up out of the woodwork, you can simply do a monument of title probate. It doesn't always work, and Nathan's going to talk about some of the pitfalls of that when we get to his section. But if mom had few or no debts, and everything is pretty copacetic with the children, this is often a very easy way to deal with passing title to the real estate and letting the kids sell the property so that they can then settle mom's estate. It does not cause the issuance of letters. So know that when you do a monument of title, you are not issuing letters. It's not a full probate. There is no appointed PR. I had one county where I practiced who kept insisting that we do the registration of out-of-state fiduciary with the Secretary of State for this, and I was like, no, we don't need that. We're not issuing letters. We're not appointing a PR. We don't need that. I finally got him to understand that, but this is a very low level of probate. And then if you look at 32-5-109, this talks about how you can simply register the will in the county where the land lies. So even if you probated, did the monument of title in the county of the decedent's residence, if their real property's in another county, then you're going to actually go over and record that will as the monument of title in the county where the land lies, if it is elsewhere in Tennessee. And I had talked with Nathan about this, and I think he's given his his title advisor stamp of approval, I always record the order admitting the will along with the will. I know there are a lot of old school attorneys who are taught to just record the certified will, but you really need that order too, because that's the thing that establishes it as the true and correct last will and testament of the decedent. So record your order and your will if you're going to do this. 32-2-101 just tells you where you need to do amendment of title if you're going to do that, and that is in the county where the testator had his or her usual residence at the time of death. Now, we're also going to talk a little bit about how amendment of title and small estate play together. And this is, for me, is a little bit of a controversy because I don't practice in Shelby County, but you know, in addition to the amendment of title proceeding, for personal property, you can do something called a small estate. And we're going to go into the nuts and bolts of it, but amendment of title is generally used for real property. Even though the statute says you can use it to pass title to personalty, it isn't frequently used for that purpose. But then the Small Estate Act applies to personalty. And a lot of us have wondered, you know, what's the interplay between these two things? Can you do both? Should you do both? I think in most counties where I practice, the court does not regard the Small Estate Act as being applicable to any situation in which the decedent died owning real estate. I've had that told to me by the clerks or maybe by the judge or other people who practice regularly there, and I think that's pretty much the consensus in Davidson County. However, in Shelby, they have this local rule, and I found this interesting. I know that there probably are some people here who practice in Shelby. They will allow you to do both at the same time. You can file amendment of title proceeding to deal with real estate and file a small estate at the same time, or at separate times to deal with the personal property. So they consider that you can do both. You know, in looking at the Small Estate Act, I don't think there's really anything that expressly prohibits it. A lot of it is just a matter of local custom. So if you're considering some of these probate alternatives or low-level probate options, then what you might want to do is talk with the clerk in your county to see how they regard these things and whether or not your county will accept a small estate affidavit where the decedent also owned real estate. Because it might be possible if some counties adhere to the Shelby County local rule. But I thought this was really interesting that they do this by local rule. So moving on real quickly to the Small Estate Act. We have undergone a lot of back and forth about small estates over the last 4 or 5 years. Those of you who have regularly attended this meeting every year know that there was a minute when the Small Estate Act was not even usable if your decedent died with a will. And it didn't start out that way. We sort of ended up in that direction. And then the General Assembly modified it again because there was so much outcry. It didn't make sense for us not to be able to do a small estate where there was a will, but we were also dealing with personal property under $50,000, which is the jurisdictional limit for this act. So we have now come full circle, and you can do this under 30-4-102. Which if you'll flip back for me. Yeah, there you go. Okay. Under the chapter definitions, you will see that it's now available for both testate and intestate estates. So it does, however, and I will caution you, some courts are more strict about this rule than others, but the limited letters are meant to restrict the person to whom they are issued to deal with only the property itemized and identified in the petition. And the clerk is directed to actually attach a copy of the petition, the filed petition, to the letters so that whomever your small estate affiant is dealing with has in writing right there what property this is supposed to apply to. I know Davidson County does adhere strictly to this rule, and so if you look at their forms for the small estate affidavit on the website, you will see that they require you to list all property of the decedent that's known to exist as part of the probate estate. And then the letters as issued to your applicant will only apply to the property listed. So be very certain that you have carefully quizzed your client about everything that is out there. You may have to go back and amend your petition later if you have not included everything. So the other thing I think to note about this is that $50,000 limit. If the value of the property is more than that, you're going to have to do a full probate. Now, if you want to switch to 103, we've got some rules about when you can do this. You're supposed to wait 45 days. You can actually request an exemption from that in your petition if there's some exigency or urgency. And I've done that before when we're dealing with especially apartment situations, and I'll talk about that in a second. But so you can get that waived, but generally you're not supposed to request the small estate affidavit until 45 days have passed from the date of the decedent's death. You can elect to, you can add, I found this a little weird, but the statute actually says that if the decedent died testate, and the testate distribution is different than what would be an intestate distribution of this person's property, you can actually elect to file the petition for probate of the decedent's will and the issuance of limited letters testamentary, or just file the will, and that's it. I think what they maybe meant was that you can go by the will. I'm not totally sure, because you really shouldn't be diverging from the terms of the will unless all the parties have agreed and you have sort of a family settlement agreement. But that's the way the statute is worded. You also need, as I mentioned, needing to specifically identify known property. You also need to identify known creditors whenever you do this. And be careful, because especially in Davidson County, the court will make sure they will not issue your letters on a small estate unless you have carefully identified all of your known creditors. You are not going to advertise notice to creditors in a small estate probate, but you are required to list them, and theoretically should probably pay them, but the statute doesn't require any formal notice. Yeah, I know, I don't get that either, but I just work here.
This is where your client needs to tell you everything.
Yeah, exactly.
You need to ask questions if you have questions.
Yes, if you are doing a small estate. I think it's also interesting to note that in a small estate, even if you have a will that waives bond, you are still going to have to get consent for waiver of bond from all of the beneficiaries. The waiver in the will is not enough when you're doing a small estate, so you're going to have to get all of your beneficiaries to sign those consents. For any of you that don't practice in Davidson County's forms that are on their website for small estate are really robust. And so if you want to do a little Adobe PDF work on those forms, I am sure that Mr. Day will not mind. And they really pretty much cover everything and are a good go-by for that.
And Hamilton County also has fabulous forms on their website. That's another great resource.
Okay. And as I said, you don't file notice to creditors. There is a statutory form of the letters of administration that are going to be issued. It's actually contained in the statute. The other reason that letters of small estate might be useful is that they also expressly empower the person named to remove personal property from a property leased by the decedent. I know you real estate guys, Nathan, sometimes run into this. If the decedent had an apartment and they've died and nobody can get in to retrieve their personal effects, and sometimes apartment management is a little hinky about that. This will allow your client to retrieve those items of personal property, and this might be a reason for you to do it in less than 45 days if there are exigent circumstances. I know our court appreciates that situation and will let you go ahead and file the small estate sooner if this is the problem. The other thing to do is to get to know all of your county's eviction lawyers. So you can maybe call one of them up and say, hey, you represent X apartments. I've got a situation over here. Can we be allowed to get in to retrieve the decedent's personal effects? And sometimes you can actually accomplish something with that. Real quickly, 30-4-104 talks about providing copies to everybody who is subject to the small estate. It's also rather interesting to note that there is some liability here. The person to whom payment is made of any of the decedent's property under a small estate administration is actually liable and remains liable up to 1 year from the date of payment, transfer, or delivery to them. To unpaid creditors of the decedent. So even though we don't give formal notice, there's no procedure for creditors in here, there is some liability on the individuals who may receive a benefit from the small estate administration. So I've not had this issue come up, but it's something that you should be aware of and may want to caution your client about. The other thing that the Act does is that it allows a court to compel the turnover of property if the letters are not honored, but it's going to require the filing of a petition and service of notice on the party who isn't cooperating. And in that event, you might be in the territory where you just need to do a full probate. So, all of these things have limited utility. They're very situation specific, but they're low-level things that you can consider that might help your client. So now I'm going to turn it over to Nathan, and he's going to talk about dealing with real property when there's not a formal probate.
So good morning. Touching on small estates, it's not on my slide, but please don't be that attorney that files a small estate affidavit and lists the real property. We've had that happen. And then the heirs go to sell the property, our title search pulls that, and we get to tell them that their attorney didn't do a great job, and we've got to go through the other hoops to get the property sold. So touching on that. But okay, so if no probate, what are our options for real property? So next slide. If you don't have a last will and testament, obviously Tennessee creates one for you. You all know that. You have the heirs at law. So what are we looking for? And I'm coming from the title attorney perspective. So I love and appreciate all you estate and probate attorneys. You guys know the law. We know the law. Sometimes when we're dealing with real estate and real property, we're going by title insurance guidelines that do not always adhere exactly to the letter of the law. And I don't like fighting with other attorneys over little things like that, but it happens. So what do we need? We need a copy of the death certificate for us to sell the property, okay? That's gonna have some information on it. We need to wait 60 days from the date of death. There are some exceptions, like if the decedent had signed a contract prior to death, there are some exceptions that they could close before the 60 days. But I had this situation this past week, and I'm dealing with it actually right now. So brother died at the end of January this year. Sister came to town, opened a probate with an estate attorney, filed affidavit of heirship within a week and a half of his death, filed a POA for the mom, who's the beneficiary because brother had no kids, was never married. They're wanting to sell the house. So red flag, really quick, wanting to sell it super fast, okay? Other red flag, they're selling it for half the Zillow value. So another red flag. There is an estate attorney involved. We're looking at it from a fraud perspective on our end because title insurance is risk, and we're looking at the risk. Yesterday I got the call that our office is being insensitive to their, I'm so sorry. We sent them a list of what we would need, which is on this slide. But these are issues that you guys deal with. So if you're helping someone and they're not probating, like in this case, it's just good to know that that 60 days is out there. I did not put the statute on there, but it's TCA 66-26-104, which gives priority to a deed from a decedent recorded within 60 days. So I've had those kind of situations happen. I had a quitclaim deed from a mom to a son that son had been holding on to in his safe for 13 years. He didn't file it because he had all these tax liens against him, so he didn't want to be the owner of the property. But that's why that statute is there. Next point on there is determine who the heirs are of the decedent, so whether that's a spouse or children. How do we get that on our end? If you're not involved, our title searchers look at the obituary. Title searchers look at Find a Grave website. We look at the death certificate. Obituaries are great, but they're also not helpful sometimes. We run into lists of brother so-and-so and sister so-and-so who actually is a cousin or a best friend for life. And so it makes our job harder. So if you can help, if you're involved in helping a client, it's very helpful to know who the actual heirs are if you have a list to provide that. And then with this, you've got the affidavit of heirship, which we'll talk about in a minute. We're going to need a TennCare waiver. And I love you guys, and I don't want to take any business away from you. So if you prefer to order that yourself and bill your client, we're happy with that. TennCare, I think, has done a great job. Their website's super easy, and we can print the form and usually get it back in 24, 48 hours, not like 2 weeks like it used to be. But our office is not intending to take business away from you. So if you want to be the one that pulls the TennCare waiver and sends it to us, if you want to be the one that does the affidavits of heirship, that's totally fine with us. We're just probably going to communicate to you some points that we like to see in there for title insurance purposes. So, all right, next slide. One thing that I see is common is we need to know whether there's any federal estate tax claims. And again, this is where we're not probating a will, and so no one's had a chance to file anything or anything like that like they would in a normal probate. So what we usually rely on is you as the estate attorney to email us or send us a letter that says, to our knowledge, this estate is not subject to federal estate tax claims, and that suffices for us. If you can't do that or you don't feel comfortable doing that, we can also have the heir sign an affidavit and indemnity agreement. We can also add language. I've had title insurance underwriters allow me to add the language to the affidavit of heirship, where I just put another bullet point that there's no federal estate tax, and we'll go with that. All right, affidavits of heirship. You guys know how to do them. There's a state statute form. General rule that I see consistently is we need one from each heir and one or possibly two from a disinterested third party. The more detailed they are about how the disinterested party knew the decedent, how long they knew them, the more information, the better. And that's where I feel like over the years, I feel like estate attorneys have gotten much better at this because we're seeing consistent themes. But it used to be when I first started practicing, mom died, here are the kids, and there's no correlation to how this person that's signing this affidavit knew mom or knew the family, anything like that. So a lot of times when we're scanning those over to the title insurance underwriter to review it, they don't like it. It's too risky for them. Okay? Again, we can prepare the affidavit of heirship, or you guys can. We don't care. It's like quitclaim deeds. If you're preparing those as part of not probating, you're going to prepare a quitclaim deed. We definitely recommend you put some information in your quitclaim deed about how the person died, the information about who the heirs are and how you found out who the heirs are. Reference the affidavits of heirship on your deed. It makes it easier for title searchers and people going back at a later date to find how the people that sold the property had the authority to do so. And then again, like I just mentioned, title insurance underwriters prefer different things in their affidavits of heirship. And then we look at, obviously, are any heirs deceased. That happens a lot. And a lot of times clients on our end don't tell us that. So if you're working with an estate and you know that a brother is predeceased, that's a great thing to let us know because we don't always know. I had a recent, probably 2 years ago, grandpa was on title, granddaughter wanted to just file an affidavit of heirship. We found out later that granddaughter was not really granddaughter, We just treated her like granddaughter her whole life. Even though her mom had been on title previously but had come off title, it wasn't a legitimate child, and it caused a big problem for the closing, and the people did not like me because of that. All right, next slide. This one's kind of important. It's because your client's going to want to know when they get their money. So how long does the title company hold proceeds? And that can vary. Sometimes a year from the date of death. That's what we used to do. When I first started practicing, I feel like that was a common theme. It has changed with the underwriters. It can be shorter, and I've referenced that TCA section right there. If you're not probating, there's no notice to creditors. So I love probate because you can file that notice to creditors. I wait 4 months and then I can cut the check to whoever. That's great. Different title insurance underwriters have varying opinions. So there are lots of title insurance underwriters out there. Some of you may be familiar. My office particularly works with Chicago Title, First American, and Old Republic. You can sell prior to 6 months after death with First American and Old Republic, but you have to hold that proceeds until the 6 months period ends when you've not done a full probate, okay? With Chicago, if you sell before the 6 months is up, we have to hold those proceeds until the 1 year passes. So 6 months is a good range. Clients don't always understand that, like in the example I was using earlier. I mean, they filed affidavits, they've opened a probate within 10 days of somebody's death. They're wanting their money like next week when they want to close. This is a TCA section that I think is very helpful. It discusses what happens the 6 months, because if there's no personal representative that's been appointed or no one qualified to administer the decedent's estate, that's where the 6 months comes from. So that's helpful. Okay. Option 2, and we're talking here about you're not going to do a probate. What if you have a last will and testament? It's useless for us if you're not going to probate it, because obviously it's not effective. It is good for determining the heirs if they're listed. That's very helpful for us. But I did go through here and also list some issues that we would address if you did probate the will. I know this section is about no will, no probate, but this kind of outlines you those 10 things what we're looking for to clear title. Sometimes our title searchers will pull court records. So if you're helping with an estate and you filed something, sometimes those get pulled, sometimes they don't. And then it's left to us to try to call the county courts and pull the records to establish who's on title or who's an heir.
Nathan, can I just jump in?
Yeah.
This is a great checklist to keep when you're working, because if you have those answers, it'll be a seamless process to whoever title attorney, whether it's Nathan closing it or someone else. If you're like, here you go, here's your package, you've done your work, your client closes on time, and you look great. So
Yeah.
I like this checklist.
So Elizabeth's one of my favorite, because when she works with trusts and estates, she will literally send it, I call it her packet. Before I have the contract in my hands, we will have everything on this list in one huge email, and pretty much my job is done. I'll say another thing from our perspective as real estate attorneys and title attorneys. We know you guys bill your clients. We want you to bill your clients. We also don't want to get chewed out because you bill your clients. So sometimes we may work directly with your client, not trying to take business from you, but because we know if we pick up the phone and call you, or I shoot you an email saying, hey, can you send me this list of things, it's possible you're going to bill your client and maybe they did or didn't give you authorization to do that. So we, as a general rule at our office, I say we're careful. We try to touch base with the estate attorney and the client at the same time and see which direction are we going to be communicating with the client, the heirs, or are we going to be communicating with you all as estate attorney? So it can be a delicate balance.
Yeah. And one thing too that I will say, if you're doing amendment of title, a lot of times I'll do that for folks and they have no immediate plans to sell the property. But one of the things I always do as part of amendment is to get a 10-care release. And I will actually go ahead and file that 10-care release with the court, even though it isn't required. I have found that most of our courts in Middle Tennessee will accept that 10-care release for filing without any additional charge. And that way it's there in case something wild happens and it gets lost, it's already lodged with the court. And if the title searcher is looking at court records, they can see it there.
Yeah.
And that's a great piece of advice.
Yeah.
You know, if somebody's deceased, just get the 10-Q release, you know, if you're helping a client.
And I've seen recently, with our title searches, some of the underwriters are charging a premium or charging more if they want to provide probate docs or provide search court records. So it's a big burden on us to say up front, yes, let's order those because we're going to pass that along to the client, but maybe we can get that from you or your client directly. So it leaves us in a kind of unique spot.
Questions? Anybody? There.
On your last slide, you have who we need to sign at closing, the executive
Oh, yeah.
heirs. Why are you guys
Oh, yeah.
requiring that the heirs? Because sometimes you have forfeits and one's mad and
Yep.
you're selling them out.
So that a little off our no will, but when you probate the will, a lot of times the title insurance underwriters, because of the risk, are just going to say, if we can get everyone to sign, let's get them to sign. Happens all the time. We think sister, who's the executor, she signed the contract. She's ticked when I tell her that I need everybody else to sign. I deal with it all the time. It lowers the risk, and we fight over that a lot. The title insurance companies have attorneys on staff. Those are the underwriters that I'm talking about. So we can go to them, and the more information we can give them to let them know that everyone's comfortable, they possibly would just let, but Elizabeth and I had one where we had a court order and the title insurance underwriter didn't want to go by what the court order said.
And I actually sent the court order draft to the title company before we went to court to make sure it was good.
Yeah.
And the description was right and everything was buttoned up, and they just didn't.
The underwriter at the end that was reviewing it after it had been filed with the court said, that's great. And that's where I'm saying we kind of battle a little bit, because we're issuing a title policy that this underwriter kind of calls the shots on, even though I've got a court order telling me to do one thing, they wanted both, you know.
Yeah.
But I think that's important. A lot of this is at the underwriter level,
Right.
and you know, whoever's closing your real estate is trying to get it done. They have a business, and you're trying to get it done. So it is always good, you know, to know that everybody's trying to get the same thing done. But it is frustrating because those underwriters sometimes kind of make up their own rules.
They do, yeah, they make up, I mean, and
Sorry, I shouldn't say that.
No, and two, you know, for those of us out there who are estate planners, is there some magic language that should be in a will that will allow the personal representative alone to transact the property?
yeah, I feel like if you put the language in there, we've all seen it, that, you know, I grant authority, the real property, my executor to have authority over the real property, some language to that effect. They will, but they're still going to ask us, can we get all the heirs to sign? Which in some cases, that executor may be maybe the only heir, or maybe one of 20.
Or expressly bringing it into the estate for purposes of administration.
Yeah.
I've seen that,
Yeah,
I
you can
think.
do that, yep. Otherwise, if it's insolvent, we've got to have the order bringing it into the estate.
Okay.
Yes.
Any special requirements for grant trust that become irrevocable upon death and then selling the real property?
Not special requirements. So trusts are completely different. We were going to want a copy of the trust agreement or the trust certification, and we're going to want to see who's the currently acting trustee. What I tend to do is on my deeds, we reference the trust agreement, but we don't usually record a copy of it. We used to record the certification of trust, but I feel like we don't even do that pretty much anymore.
Interesting.
Yep.
The question was, in amendment of title, does the property need to be owned free and clear, or can there be a mortgage on it? And the answer is there can be. All that amendment of title does is establish the chain of title to the property. It doesn't really affect any liens or mortgages or other encumbrances that might exist on it. So the person taking subject to that transfer in that will is going to take it subject to the mortgage or other liens that are out there. It's essentially kind of works like a quitclaim, essentially. It's a transfer of the decedent's interest in the real estate to the person or persons named in the testamentary instrument.
That's a good question.
And that's a great point too. If you're
Yeah.
preparing quitclaim deeds, be aware for your heirs, be aware if there is a mortgage on the property, that can sometimes trigger the due on sale clause in the note. Not always, but we've seen it happen. So like our office, just in general, anytime we're preparing a quitclaim deed, we give that caveat because it's happened.
I'm going to throw something in there about mortgages. So a lot of times if there's a property that's mortgaged, when I was in private practice, and someone came, we always encourage them to keep that mortgage current and then request reimbursement from the estate. But sometimes you have kids and they're all like, we're not going to pay. And we really, as lawyers, need to say, somebody needs to pay or y'all all need to go together, keep records. That's a great use of a family settlement agreement. Who did what, who's getting money back. When the, small estate affidavit goes through and there's some cash, or actually you can't do that because of real estate.
You can in Shelby.
Yeah, but if you're
But
in
everywhere
Memphis. But I think that family settlement agreement, for something like that, keeping a mortgage current is a big deal, because if the house goes,
You
that's
got
the
nothing.
biggest asset that's usually nothing. So,
Exactly. And for those of you who have clients sometimes more like mine that just don't even have the money, any way they can scrape together money to pay that mortgage, hoping to get reimbursed on the back end, is a good thing, because, as Elizabeth pointed out, if the foreclosure takes place, then the property's gone and you've got nothing to argue about anymore. And sometimes if that happens, you're literally giving away hundreds of thousands of dollars. A lot of our decedents may have paid down their mortgage substantially, and there may be very little owing on it in proportion to the value of the real estate. So it's all a cost-benefit analysis. Whenever you use any of these non-probate or low-level probate tools, you're making a cost-benefit analysis for your client. And I think maybe you want to look at it that way. Do I really need to go do a full-on probate? Do we need to advertise notice to creditors? Do all of these things need to happen? Or can we do something that will end up costing the client a little bit less, but achieve the same result? And I think that's what we're all about here. Question in the back.
For these options that you're sharing about minimum and affidavit of heirship, once they're established and all the checklists and forms are done, is a quitclaim deed still needed? The chain of title?
That's a Nathan question.
I would probably do one. I would probably do one just to be clear and clean it up. We see people record the will because it works for transferring title. We see people just record the affidavits of heirship. I think it's helpful to do the quitclaim deed personally.
we've got time for 2 quick questions if y'all are quick.
What have you seen about creditors' claims and timeshares and probate?
Oh,
No.
Claims like the uncle maintenance fees, and especially the ones in state. I know there's some in Las Vegas, Disney World, and all that. But what about in-state timeshares?
I'll be honest, I will not touch a timeshare.
Yes.
I know nothing of. I mean, I've had clients come and want to get rid of them, but we have not.
Yeah.
I personally have not dealt with one as part of an estate. or anything.
Timeshare equals minefield. You could just think about those 2 words together. Really quick.
Yeah, I just have a quick question. If you have an uncooperative heir who will not sign an affidavit of heirship, they agree when you sign, is that something that you would memorialize in a deed, or how would you handle that?
Possibly. That is more of a title insurance requirement. Usually, if we can go and say, if they're still getting a piece of the pie, the underwriter might allow us to not get one directly from the heir. It may be a situation where we get another disinterested party. So instead of 1, 2, or maybe even 3, plus the other 2 heirs. And then as long as we're still giving that heir a piece of the pie, then we could probably get it through that way, I think.
That's great. Thank you, everybody.
Thanks, y'all.
Yeah, thank you.